The 36th District Court in the state of Michigan is now in session. The Honorable Judge Marlena Taylor is now presiding. At this time, there will be no talking, no smoking, no chewing gum, no eating or drinking, no sleeping or laying down, no driving or riding in a moving vehicle. Please keep your device on mute until addressed by staff. Also, keep your device on a leveled surface so that your face may be seen. Good morning, Your Honor.
Good morning. We just have someone check in.
Yes.
Okay. Go ahead and- oh. Michael Walker.
Michael Walker here. Can you hear me, Judge?
Yes, please turn your video on. Turn on your camera. Okay, thank you, Mr. Walker. Mr. Walker, I'm going to put you in a breakout room so you can speak with the attorney about your case.
Okay.
That's me. All right, what we're gonna do is we're gonna go for probably about an hour, and then we'll take a break so I can do my morning docket that I have that they put on here. And then we'll move forward with the rest of the witnesses. So hopefully it won't take too long. I don't have that many people signed in today, but I do have a few people signed in today for it. So this is defendant's motion. So I don't know if you've worked out if you're gonna call witnesses first. Either one of you have to would like to make a statement first before we begin with taking testimony.
Excuse me, Judge.
Oh yeah, let me call the case.
All rise.
All right, you may be seated. Now calling the matter of People versus Nakia Wallace. This is Z ticket 808261. That's one count of interfering with the government employee performing their duty. Count 2 of that same ticket is loitering, impeding pedestrian and or vehicle traffic. Appearances for the record, starting with the City of Detroit attorney.
Good morning, Your Honor. Alexa Schneider for the People, P80322.
For counsel for the fifth.
Good morning, Your Honor. Nancy A. Parker, P number P84325, on behalf of defendant Nakia Wallace.
And Ms. Wallace, can you stand and state your name, please?
Nakia Wallace.
All right, I'm gonna restate what I said before because I didn't realize I had called the case, but this is the defendant's motion, but the people I think are going to present witnesses. Is that how this is working this morning?
I believe so, Your Honor. Actually, I have a preliminary issue / question. And I know I'm not the original attorney on this case. I don't believe Sister Counsel is the original attorney. I don't know that Your Honor was the original Your Honor on this case. It is a very old case. I'm a little confused as to where we are in the process. I don't know, has Your Honor found a presumption of vindictiveness?
No.
We're having, okay.
So I have not, and I can bring both of you up to date. I have not found a presumption of vindictiveness. Right now, I'm still in the fact-finding stages. What was requested by previous defense counsel, who was actually present online today, is that they did file a motion seeking to have an evidentiary hearing. If I was willing to, I granted the evidentiary hearing a while ago. It was last year, and I can give you the exact timeline. It was back at near the end of 2021, I believe, that I actually granted the evidentiary hearing, and they had filed a stay with the circuit court. They believed I shouldn't be able to grant an evidentiary hearing to find out more information, but the court returned it and said that I could indeed proceed with having an evidentiary hearing. So we're just at the stage now where I'm still getting more information and trying to find out if there was or it did rise to the level of the prosecution.
Just for that matter, Your Honor, I know it has been addressed to me appeal, but I do object to having the evidentiary hearing today. The status of the case law is that if Your Honor has found a presumption of vindictiveness, then the people have an evidentiary hearing to rebut that presumption. If Your Honor has found actual vindictiveness, it just goes to remedy. If sister counsel and or brother counsel, I don't remember who wrote the motion, has not through their motion applied facts or has led Your Honor to believe there is that presumption, I don't think it's appropriate to have an evidentiary hearing. Your Honor, through the case law, looks at the four corners of the document, looked at the evidence provided by Ms. Wallace's attorney. If Your Honor does find that presumption, then of course you have the evidentiary hearing to rebut that presumption.
Counsel's response?
Your Honor, the city's position is wholly inappropriate. There was literally probably like a year-long litigation over this issue of whether Your Honor has the right to call this evidentiary hearing. There is no way that they can now raise either new arguments at this stage or arguments that they didn't fully flesh out. We are here today for this evidentiary hearing, Your Honor, and we would like to proceed.
As a response, Your Honor, the appeal, which I did read, and then read the response to the appeal, I don't believe it's about the actual having an evidentiary hearing without finding a presumption of vindictiveness. It was about the finding of the presumption or about whether or not there was actual vindictiveness. And I understand Your Honor's position, of course, it is a very old case. We've been here before. Your Honor's been here many times, but of course, we all do have to follow the case law. I have cases ready. There is a Gordon Pritchard v. Hayes. I have a copy for Your Honor and sister counsel. In that case, it talks about the burden for the presumption. It states that the court has emphasized the due process violation may not have possibility that the defendant might be deterred from exercise.
I'm sorry,
right,
slow down.
may not be deterred from the exercise of a legal right, but rather in the danger that the state might be retaliating against the individual who would wrongfully attack their conviction.
So would you like me to find that I find the presumption of vindictiveness? That way you can bring your rebuttal witnesses to that?
I would give it Your Honor's discretion. If Your Honor does find that, I would just ask what the finding of presumption is, so we know what.
Your Honor, in response, I would like to say that first, defense counsel has fully pleaded this issue, and we believe that the pleadings in the briefs itself alone, you will be able to find a presumption. However, I continuously object to the city now raising a brand new argument. The timeline for them to appeal your initial evidentiary hearing is way overdue. Even the appeal that they filed, we found that to be untimely. Your Honor, there is no way that they can now, years later, after your evidentiary hearing finding, bring another claim that it was improper. So we object on that ground. But again, Your Honor, you right now, before even presenting any evidence, any witnesses, excuse me, you completely on the facts that have been pled in the briefings, Your Honor, we have pled a presumption of vindictiveness.
Let me pull up so I can give you the exact timeline, and I'll give you the presumption of vindictiveness is why we're handling this case today. I know there was a motion filed. Give me a second. I'll correct.
I have a
You said you have some caseload?
That's right.
I may not be right. You may approach.
I have several, I don't know how many you like. Reagan v. Poindexter, it's short.
I'm sorry, you said we're back on record? No, not on record. You don't have to, I just want you to fix it. That we brought at 9:25 on the day of the hearing. Yeah.
Goodwin, Point, Grace, Braden, or Poindexter, and Doors, Gordon.
Reagan's the shortest, the easiest. I mean, I'm on my counsel, I'm irritated, so I'm trying to take a deep breath that you will give this to me on the day of.
My apologies, Your Honor. I wasn't sure where we were either. I thought.
So that's why we have hearings to figure out and ask questions beforehand, right? And I'm the type of person who will allow you to come here beforehand. It's frustrating because I already have a docket that I didn't want to have this morning. because I want to take care of you all. And if I'd have known this, then we could have done something here online before this hearing to stop us from having people come down, and come back, and come down, and come down. I only have until noon to be able to do this today. And we gotta go ahead and do my docket, which takes about 45 minutes. And y'all sat down here the whole last time. The court is frustrated. I'm gonna take a moment and read through this because I want to make sure I continue to make the correct decision. So give me a moment.
Thank you. I appreciate Ms. Hawkins, Ms. Walls.
Absolutely. Take care of the court.
Okay,
Thank you.
Okay, Evans Villanube. Evans Villanube, take your phone off mute, please.
You might have to ask for that. But, all right.
Galen Wooten. Galen Wooten. Galen Wooten.
Yes,
Good morning, sir.
good morning.
He's not on the docket today. Yeah, I don't see him. Did you call the court? Mr. Wooten,
Yes,
will you write this number down so that you can call the courtroom and talk, with personnel there?
yes. 1 second. What's the number?
965
965
2293.
2293
Yes,
313.
yes,
All right.
thank you. Evans Villanube. Evans Villanube. Can you hear me? Take your phone off mute, please.
What's my P number? P80322.
didn't interrupt you, Renee, but as I'm trying to quickly go through these cases, I just want to assert and remind Sister Council that her counterpart has already cited some of these cases that she just handed me in their response brief. This isn't appropriate to now try to re-argue points that the city has already made.
I just want to make sure I did it the right way online, so on the record, so I'm just making sure. I do that, see that some of these cases are the same.
Yeah, it's not new, it's not a different argument, it's the exact same argument.
Original charges that was filed in the CR. So I need to get them signed. The art, sure, actually, no one take it. This is it, right? All right, we can go back on the record. Council has presented, well, the city has presented some cases. I do note for the record that, defense counsel did bring up the fact that these were some of the original cases found in the original, filing that took place. No counsel's here today, nor the judge is, the original person on this case. However, one of the things that, City of Detroit Council, and you can correct me if I'm wrong, says that I need to establish is whether or not there was vindictive prosecution, or the establishment of vindictive prosecution, presumption by the prosecutor's office. It appears that there are two prongs as per the case, Bargan, Bargan versus Poindexter, which is a United States, Court of Appeals Sixth Circuit, finding. And those two things I need to find is first, that the prosecutor has some stake in deterring defendant's exercise of his rights, or second, I would say his or her rights, and second, that the prosecutor's conduct was somehow unreasonable. The establishment of timeline, as far as I can see, is that Ms. Wallace was arrested back on June 10th of 2020. The proceedings of came before this honorable court under the jurisdiction, at that time, sitting judge was Miriam Martin Clark. She dismissed that matter on February 21st, 2021. Now, it looks like in the interim, on August 31st, 2020, this is prior to that court hearing with Judge Martin Clark, there was a filing in federal court in relation to what happened back on June 10th of 2020. It then appears that on March 10th, 2021, there was some type of action taken by the court of the judge over in federal court. And I did see, I think it was Judge Michelson who sat in that court, that adversely affect the city of Detroit, or can be considered to adversely affect the city of Detroit. It looks like charges, the original charge that was put in for Ms. Wallace was that of disorderly conduct. That was the original charge back in June 10th of 2020. After it was dismissed, there was no refiling of these exact same charges. Instead, on May 4th of 2021, there was a refiling of interfering with a government employee performing their duty, as well as a count of loitering, impeding pedestrian or vehicle traffic. I do think count 2 was also an original charge that was made at that point in time, but it was just impeding pedestrian.
Can't hear it? I don't know if it's my machine. It's my-
I believe it essentially contains the same acts, the interference that this woman was accused of. She was shoving allegedly against shields, shoving at shields, swearing, refusing to move. He was taken away by officers. The loitering, as also as Your Honor said, it was an original charge. I think it is appropriate. I think it's in line with what happened.
So we went from a broader charge to a more specific charge, that being interfering with the city government, correct?
I would believe it's more specific.
All right. Any response?
Your Honor, if I may just briefly respond, again, I continuously object on record. But in response to what Sister Council just stated, that case as well as the Gordon Kircher case that she presented to you, and again, in regards to a defendant not taking a plea offer and then the prosecution charging more charges that they threatened to charge if the plea deal was not taken. That is an opposite to what we are talking about today. There was never a plea on the table. We are talking about one single charge, Your Honor, and it was always just disorderly conduct. For my client, they did, and again, to refresh the recollection of the court, hundreds of protesters were arrested, and so there were various charges. My client, Ms. Nakia Wallace, was only charged with disorderly conduct. That was completely dismissed, and like you said, Your Honor, the most reasonable thing, prudent thing for a prosecutor's office to do would be to refile those charges that they initially brought, if that was the charge that they believe was sufficient. Moreover, it would be close in time. We are talking about almost a full year after that July 10th incident, that then we have additional, as much as the city has the legal authority to charge, to double the offense and trying to, hide the ball by saying, oh, these are different charges. Yet again, we're hearing, but they're substantially the same. We argue that they are not the same charges, they're different. It bears no reasonable conclusion that a prosecutor's office would take the actions that it did, as Your Honor has laid out in that timeline, but for to be vindictive, but for to retaliate against my client. And so I just want the record to reflect, again, we object to the new case, People v. Watts being raised here. We believe that, and the Gordon Kircher, we believe that these cases are inapposite as they are talking about a plea deal where the prosecution threatened to the defendant, hey, we will charge you X, Y, Z if you don't take this plea deal. That is not what we're dealing with here. And Your Honor, we believe that you have correctly found the presumption.
Well, from the year, it was a year from the incident, but you agree that from the dismissal of the charges, it was from February to May, so it wasn't as long for the dismissal of the charges, correct?
Correct. And for that point, Your Honor, we would say that there was 7 months. There were 7 months from that initial filing on July 10th, issuing of that charge until the dismissal in February. During those 7 months, that would have been the time where the city should have been looking for the evidence if they truly did believe that the charges that they brought. Defense counsel brought numerous discovery motions, clearly stating this will be dismissed if there is not evidence. I don't know what other time would be more appropriate than a current motion to dismiss for discovery. The city allowed that charge to be dismissed because they did not do any due diligence. They did not know but where the body cam footage was, who the arresting officer was. It is not until there are severe blows in the federal case that they then say, okay, yeah, we need to stick it to Ms. Wallace and then file these new charges. It makes absolutely no sense, but for vindictiveness. The timing alone, the correlation is not a coincidence, as the city will have you believe, Your Honor. We believe that that's an insult to this court's intelligence. It is clear. There was a 7-month period where these discovery motions, not the motions, they weren't pending for 7 months, but the charge was pending for 7 months. There were numerous discovery motions throughout all the courtrooms. Nothing was produced until almost a year from the arrest and months after the district court dismissal and shorter months from the federal court dismissing the city's counterclaim, Your Honor. We think all of that evidence is beyond enough to suffice for the level of proving that one, that the prosecutor had a stake in deterring Ms. Wallace advocating her First Amendment rights to free speech, to criticize the city and DPD, to file a federal lawsuit against the city, and then the prosecutorial decision to then charge her with double the offenses almost a year later can only be seen as unreasonable. The timing leaves no other conclusion. Thank you, Your Honor.
Very briefly, Your Honor, the sister council is correct. They were voluntary dismissal in February of.
Objection, Your Honor. That's inaccurate.
Well, you don't have to interrupt. I was gonna say, I get it. That's not what that's not what the court document says.
They were dismissals placed by my officer. He dismissed because we were facing motions to dismiss for the discovery issues when we were putting in the body. We agree, we can see that we didn't have the body cam at the time that Mr. Council is correct. All of the protesters filed identical motions on the same discovery issues. All but one were dismissed at that time. We agree with that. After the task force was created, we had 2 out of 13 federal plaintiffs, including Ms. Wallace, had their charges reissued from July 10th. 11 were not. The cases couldn't be put back together. 6 non-federal plaintiffs did have their cases reissued. For timing, I think it's important to note that motion, there was a stipulated order to preserve the status quo in the civil case filed by the city and the coalition in September 18, 2020. Then the city files their answer as a counter complaint September 25th. It's a very simple counter complaint and alleges civil conspiracy. It was struck down on a legal issue. They built to properly plead the underlying tort. Very simple, very small issue. The motion to dismiss the counter complaint was filed in October of 2020, and the criminal cases weren't dismissed pursuant to that discovery issue until February of 2021. The city knew the counter complaint was likely to fail, and they knew they were attacking the counter complaint when the criminal cases were dismissed. So it wasn't the counter complaint being dismissed in March of 2021. A little under 2 months later, the criminal case being reissued. I don't think that rises to the level. I don't think it's significant.
You said it took them 7 months, over 7 months to review the camera video? Hold on, Detroit Police Department, right? That you're able to list every single person who will have the video footage, right? And the video footage is to be downloaded at the end of the day by each officer after they turn it in and upload into the system for that particular case. And then you're able to, like, whatever they have on that cam that day, whatever people that they arrest on that day, they're able to see and preserve it. Preserve it. It used to be for 90 days. Is it still 90 days now? More than that now. If it's a pending case, they have to hold on to it indefinitely. So from that point in time, and you may not know the answer to the question, but how many people were arrested on that time period on that day? Because they were arrested because they had violated the law, right? Correct. They all had body cams on, right? Correct. So those individuals who had the body cams on need to be able to see it. And then it pended in this court. I'm just making sure I'm getting the timeline right. It pended in this court for 7 months with no videos turned over at that point in time, or were there videos turned over and it just wasn't very clear?
There were some, it was not what the coalition wanted. I don't know that they still have all the videos they want. They have, the issue is at the scene, it would be sort of a chain of one officer to another. So officer A witnesses the activity, takes the person to officer B, who then takes them to officer C, puts them on the bus and goes to B and C. The issue isn't having body cam for the individual officer, it's tying officer A to Ms. Wallace to this action on the license.
But they have testimony, right? Even if you don't have cameras, you have the testimony of the officers, right? So I guess my question is, and this is why I'm giving you a lead to why I'm asking for this hearing today. Because my question is, why isn't that officer's testimony sufficient? Even though we do have body cams and those things, if that officer saw some type of action taking place against the person, that's enough to keep that charge going. But and I mean, that's why I alleged that the court had dismissed it. That's why I was asking more questions, because if the court just unilaterally dismissed it, then it's understandable. It's all like, hey, we wanted to move forward because we say in spite of there being no camera footage that they can see, testimony of credible witnesses is enough for a court officer or for a jury to decide. But you're saying that the office dismissed it. So if the office dismissed it, that's why I want testimony, because I want to know, was there a reason why it was dismissed? Because body cameras and everything, there were times when we had crimes and there was no body cam. And that doesn't mean the crime wasn't committed.
There were, I don't have the discovery motions in front of me, Your Honor. They were motions for dismissal. They were citing MCL that requires, both pending cases. They were facing a dismissal with records.
Your Honor, may I respond?
Okay. And then before we take testimony, I started doing one more thing. Go ahead.
Your Honor, it truly is bewildering to the defense counsel how the city can continuously lie in the court and state that Ms. Nakia Wallace's case was dismissed unilaterally by them. That is unequivocally not true. Defense counsel was then my colleague, John Royal, who's on the Zoom right now, filed the motion. Another colleague of mine, Jeffrey Leonard, was present that day. It was Judge Martin Clark was hearing our motion to dismiss. This was not part of the city unilaterally dismissing hundreds of cases. It simply was not. City needs to stop regurgitating that lie. The record is beyond clear. We filed the motion. Judge called for the hearing. On the record, it says we are here for the council's motion. The judge didn't need to hear any testimony. The judge said, I am granting the defense counsel's motion and issuing an executive order dismissing all the BLM cases. It was brought on our motion to your exact point, Your Honor. Where is the body camera? All right, you said there was a chain of event issue. We don't have the body camera. Bring the arresting officer to testify. Bring the complaining officer to testify. City could not identify any of those people for 7 months, Your Honor. The city could not identify who the arresting officer was for Ms. Wallace, could not identify any complaining officers who were there and saw any alleged misconduct by Ms. Wallace. Therefore, the judge granted the defense motion to dismiss for lack of responsive discovery. There was no way that we could move forward without any information, without anyone to testify to, without any direct evidence to show, without the body cam footage, without any officer saying this is what Ms. Wallace did. The case was dismissed. Simple as that. Thank you, Your Honor.
No problem.
I would inform you it was a voluntary dismissal. I'd ask you to transfer, Your Honor.
Your Honor, I have the transcript right now.
Well, good, because the court is going to take a break from this matter. If y'all want to look over the transcript real quick. We'll come back to this in a moment after I do some more matters. Thank you.
Thank you, Your Honor.
Good morning, Attorney Lawson. Lawson. Attorney Lawson.
I'm sorry, Judge, good morning.
Good morning. I
Oh,
was
wait.
just typing my note to see if you were doing another matter right now.
I am?
No, I didn't know if you were in another courtroom because you weren't responding, so I was gonna text you a message to see.
Oh, thank you. No, my sister called me and I had to hang up on her.
Oh, I understand, no worries. I just was making sure because I know that you do other matters as well. Okay, I'm gonna try and get you out of here, okay?
Whatever you need to do, Judge, I'm ready to go.
All right, fantastic. I'm gonna call in Matthew Wilson first. Matthew Wilson.
Yes, here.
All right, and now calling the matter of the people versus, hey, hold on a minute. Sorry. Now calling the matter of the people versus Matthew Wilson. This is ticket number SP 155555305. One count, no operator's license in possession. Ticket number SP 1224969. One count, drove while license not valid or improper license. Ticket number SP 1159823. Failed to display a valid operator's license not on person. And ticket number SP 1362724. One count, drove while license suspended, repeat offender. Appearances for the record, starting with counsel, please.
Your Honor, I'm Daniel Wozak. My bar number is P35225 with the defendant. Mr. Wilson, will you please tell the judge your name?
Matthew Wilson.
Your Honor, Mr. Wilson only had 3 tickets on the docket, and he showed me a proper driver's license. He also posted bond to get this court date. I was hoping that showing proper documents would get rid of these tickets, but you read 2 of them into the record that I didn't have notice of.
There must be a warrant status or not on my docket for today. You said he has a valid license now, though?
Oh, excuse me, just one moment, Judge. Mr. Wilson, you're the gentleman who told me you had some future court dates, correct?
I was told I got one on May, I
Okay.
think.
Okay, yes, Judge, he did try and advise me of that, so I told him to mention it when we got to court. Do you know if the offer encloses all 5 tickets?
It does. 1, 2, 3, 4. It does 1, 2, 3. It was 4 counts. Yes, it does include all 4 counts.
Then I have 3 counts of no license, and he showed me a valid license. Remind me of the 4th charge.
They're all drive while license suspended, drive with no license, fail to display a license, no operator's license in possession.
Well, I am glad to let the court know that Mr. Wilson did show me his driver's license. It was issued just last month, February 18th, and it expires in 2026. I am just now downloading the offers from the city, but I'm hoping he can dismiss proper documents.
You want me to run an SOS to make sure it's valid? All right, so the court is going to grant your request. I'm going to dismiss this without prejudice because he now has a valid license. Sir, keep that license valid, up to date, and in your vehicle at all times, okay?
Yes.
All right, there's nothing further. You're all set.
No, one question.
Yes, sir.
But I mean, my driving record is all clear.
Mr. Wilson, as we discussed in the breakout room, we will not know that. We are not a state agency. Only the Secretary of State can tell you if your license is currently
So
valid.
contact Secretary of State.
We
Okay.
checked this morning and it appears to be currently valid. Yes. Okay, but just ask Secretary of State, they'll tell you. Okay, is that okay?
All right,
All right, good luck, sir.
all right.
I'm gonna call some other tickets you don't have on the docket for Tommy Walker either, okay?
You're scaring me, Judge, but okay, I'll believe you.
And, all right, Tommy Walker,
Oh, okay.
Yes,
okay, turn on your camera for me, please.
yes, ma'am.
All right, now calling the matters of the people versus Tommy Lee Walker the fourth. This is ticket SP 1260680, one count no insurance misdemeanor. Ticket number SP 1260672, count one, drove while license suspended. Count two, drive unregistered untitled vehicle. Count three, improper plates. Ticket number SP 1260622, count one, make sure it's on the docket. Dirty, obscure, and properly displayed plates. Count two, expired plates. Count three, no receipt of or unsigned registration. Ticket number SP 1116309, count one, improper plates. Count two, drove while license suspended. Then we have some tickets that went into default that I have. SP 1125800, count one. Let me see. Never mind. Okay, those are in default. Never mind those, that last ticket. Appearances for the record, start with counsel, please.
I'm Daniel Wozak on the defendant's behalf. Sir, will you tell the judge your name?
Tommy Lee Walker the fourth.
Your Honor, there is a recommendation, but I did not have an opportunity to review it with Mr. Walker. He was not in the breakout room by the time I got back to him.
Yeah, it bumped me out.
All right, so that's okay. Mr. Walker, I'm gonna put you back into a breakout room so that you can talk to him about your case, okay? If you click
Okay, thank you.
on your phone in the corner, do some dots pop up and say breakout room?
Mm-hmm.
Go back to room number 6 for me, okay?
All right, thank you.
And when we finish, we got a few other people. When we finish, he'll come back in there and talk to you, okay?
All right.
All right,
Thank you, Judge.
of course. Keenan Wilkes, did you talk to him or her?
Wilkes, Wilks?
Mm-hmm. AES.
No, no, Judge, I don't. Oh, yes, Keaton Wilkes, yes.
Yes.
I did, yes.
All right, here we go. Now calling the matter of the people versus Keenan Wilkes. This is ticket SP 1210579, count one, open alcohol in a motor vehicle driver. Count two, drive unregistered untitled vehicle. Also calling ticket number SP 1339073. Count two, no insurance misdemeanor. Count three, open alcohol in a motor vehicle driver. Appearances for the record, starting with counsel, please.
Daniel Wozak with the defendant. Mr. Wilkes, will you step into the camera and show and tell the judge your name, please?
Yes, Keenan Wilkes.
Your Honor, I do see the recommendation for Mr. Wilkes. He would accept that, but it's been my experience that alcohol in a vehicle driver, they are usually willing to amend to alcohol in a vehicle passenger. Do you know, they did not indicate that. Do you know if they would agree to it?
I don't think so. It's because he has two counts of the same thing, a year
Oh,
apart.
yes, I remember that now, Judge. We better just go ahead as it is.
Okay, Mr. Wilkes, the offer today is that you plead to one of these open alcohol in a motor vehicle driver. The other one will be dismissed. I do know it carries points on your record, 6 points. You have the option of either taking this offer today or going to a bench or trial. How would you like to move forward, Mr. Wilkes?
I could take this offer today.
Okay, if so, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, sir?
Yes.
All right, you can put your hand down. Did you have a chance to talk to an attorney about your case and about your rights?
Yes.
Did anyone threaten you, force you, or promise you anything in exchange for a plea today?
No.
Are you pleading guilty of your own choice?
Yes.
Are you pleading guilty because you are guilty?
Yes.
Do you understand that by taking this guilty plea today, you're going to give up the rights that you had to have a bench or a jury trial in this matter? You understand that, sir?
Yes.
Understanding all of that, did you still want to move forward today?
Yes.
All right, sir, I want to take your attention back to the date of June 15th of 2021. Were you in the area of Greenfield and West Auto Drive in the city of Detroit driving a Ford vehicle?
Yes.
And did you have open alcohol in the motor vehicle on the driver's side, sir?
I'm sorry, one more time?
Did you have open alcohol in the motor vehicle, sir, on the driver's side?
Yes.
All right. Satisfied, counsel?
Yes, Judge, I'm satisfied.
Stipulation for probable cause on the remaining counts to be dismissed?
We stipulate.
All right, so at this time, the court's going to enter one plea of open alcohol in the motor vehicle. The remaining counts called on this record today will be dismissed. Mr. Wilkes,
Yes.
you cannot drive with alcohol in your vehicle like this. Do you hear me?
Yes, ma'am. It was an old beer bottle on the back seat, in the back seat of the car.
We cannot have those in our vehicle, sir, okay?
Yes, ma'am.
Because you apparently didn't learn your lesson from 2021 to 2022 because you got the same charge.
Yeah, I got to stop keeping cans and bottles in my car.
Put them in your trunk. Put them in your trunk.
Yes, ma'am.
All right, my fine is $240. How long will that take you to pay? 30 or 60 days?
60.
Okay, all right, I'll give you until May 23rd to have that paid, okay?
Okay, thank you.
You're very welcome. Remember what I said, sir, in the trunk, please. Thank you. Don't drink
Yes,
and
ma'am.
drive.
Is there a way I can check maybe my driving record or how many points I have now, maybe?
Yes, so if you go to the Secretary of State's office and ask them for a printout, they'll be able to tell you all the information that you need to know. I did want to arm you with the information. This is a 6-point offense, okay? So it's 6 points with this one.
Okay, thank you.
Okay, but you can go there and they'll give you a printout and let you know all the points and all the information you need to know, okay, sir?
Okay, I appreciate it. Yes, ma'am.
Of course. All right, you have a great rest of your day. Get back to work, okay?
Okay, you too. Thank you.
I will, thank you. Tiffany William, you talked to her?
Yes, Judge.
Okay. I'll just ask you before they come in, because I know sometimes they do fall off, so.
Yep, no, I did her. She's gonna ask for a pretrial.
Oh, that's fine.
She's an arraignment on a bench warrant.
Miss Tiffany William?
Yes.
All right. Now calling the matter of the people versus Tiffany William. This is ticket SP 1287280. Count 1, allowing an unlicensed driver to drive. Count 2, no insurance misdemeanor. Count 3, drive unregistered untitled vehicle. Appearances for the record, starting with counsel, please.
Daniel Wozak with the defendant. Miss William, will you tell the judge your name, please?
Tiffany William, no S.
Your Honor, I had a long discussion with Ms. William regarding this type of ticket. She is going to request that the warrants be recalled and a pretrial set so that she can report this event to both the Secretary of State and the Detroit Police Office.
All right, Ms. William, I'm going to set this for May 24th. May 24th at 8:30 a.m. I'm going to enter a plea of not guilty on your behalf. I think it was an arraignment on bench warrant.
Yes, it was, Judge.
All right, the court is going to recall the warrant and enter in a bond. Did you have to pay a bond at all, Ms. William?
No, ma'am.
All right, I'm going to enter a bond of $0 personal for her, and we'll see you back May 24th at 8:30 a.m. via Zoom. That should give you enough time to take care of all those matters, okay?
Okay.
All right, there's nothing further. You're all set, ma'am. I'll see you then.
Okay, thank you.
You're welcome.
Bye.
Bye-bye. All right. Now I think, is Ms. Wins here for she's here for a review, so I'm gonna have to find out what's up with that. Wow. You talked to Marsha Watkins?
Yes. Excuse me.
You okay? Now call it, you can unmute yourself, Mr. Watkins, for me. Nah.
Okay.
Now calling the matter of the people versus Marshall MacArthur Watkins. This is ticket SP 1132161. One count drove while license not valid or improper license. Appearances for the record, starting with counsel, please.
I'm Daniel Wozak with the defendant. Sir, will you tell the judge your name, please?
Yes, Marshall Watkins.
Your Honor, Mr. Watkins would like to plead no contest, partly because of the age of the ticket. He simply does not remember if this ticket was one where he was suspended or expired, or what the condition was of his license.
All right. You had a discussion with him though, and this is appropriate for me to do this, Attorney Wozak. Oh, it's okay, Carl. Take your time.
No, I did explain to him that it would be the same as for sentencing purposes, the same.
Okay. You can put yourself on mute. If you need to get some water, go grab some. Sir, will you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Did you have a chance to talk to an attorney about your case and about your rights?
Yes.
Did anyone threaten you, force you, or promise you anything in exchange for a plea today?
No, ma'am.
Are you pleading guilty of your own free will?
No, I'm pleading no contest.
No contest. All right, and do you understand that for the purposes of this plea, that no contest plea is to be treated the same as if you pled guilty on your own, sir?
Yes.
And the basis for the no contest plea is lack of memory, sir?
Yes.
All right, and do you understand that by taking this no contest plea, you're going to give up some rights that you had? You're going to give up the right to have a jury trial, that's a trial before 6 members of the community, or a bench trial, that's a trial before myself. You understand that, sir?
Yes, ma'am.
And by taking this no contest plea, you understand that it's the same as taking a guilty plea, just not making a factual basis. You understand that, sir?
Yes, ma'am.
All right. Reading from the ticket to establish a factual basis on the date of November the 3rd, 2020, in the area of Bucharest and Santa Maria in the city of Detroit, Mr. Watkins was driving a Hyundai vehicle and his license was not valid at the time. Satisfied, counsel?
Yes, we'll stipulate to that, Judge.
At this time, the court, it was no lower charge, Attorney Wozak, it was just a drive while license not valid?
Yes.
All right, so at this time, the court's going to enter a plea of drove while license not valid or improper license in this particular matter. Sir, my fine is $200 typically. Are you able to pay that?
At the moment, no, ma'am.
All right. You can do some community service, perhaps? Do you want more time to be able to pay it?
I can pay it within I can pay it with, I just need a little bit more time just to pay it. I can pay it.
I can give you some time. How much time do you need? Usually I give people 30 to 60 days.
30 days, 30 to 60 days is okay. That's more than enough time.
Okay. All right. So I'll give you until May 23rd. Give you enough time? Are these cases that he has in front?
Yes, ma'am.
Oh, do you have some outstanding tickets? Some outstanding tickets in this position right now?
Yes, ma'am. And other counties, I'm actually getting everything I need to do to get my license back.
For us though, on this ticket, you have one, I'm pretty sure it's the same day. Did you get a defective brake lights or windshield or something like that ticket and an improperly displayed plate ticket too that day?
Yes, ma'am.
All right, so I'm gonna waive the cost and fines on this ticket because you have to pay the cost and fines on that other ticket, okay? Those other 2 tickets.
Okay, thank you.
Okay, you're welcome, because they're in default now, so I can't bring them out. They're a little older than I like to bring out, so yeah, you gotta pay for those, okay? But I won't charge you anything extra.
I understand.
Okay, all right, Mr. Watkins, then you're all set. Don't worry about that payment. I'll make it $0. You just gotta make sure that you, pay those other tickets, okay?
All right, and these are the tickets that I can just pay at the kiosk.
Yep.
Okay.
Yep,
All
they
right.
are. I was gonna say, they're just those 2 tickets, and then you don't owe, that'll close you out for the, Detroit, as far as I can see, unless you got some other tickets.
No,
Recent.
ma'am.
All right, so that should be all of these for Detroit then, okay?
Okay. Thank you.
You're welcome. Okay, I was gonna say, she can come in here and get it. All right, thank you, you're all set.
All right. Thank you. You have a blessed one. I appreciate it.
You too, thank you.
Okay.
No.
Let me call. Talk to Michael Walker. Now calling, the matter, you can both unmute yourselves. Now calling the matter of the people versus Michael Walker. This is ticket SP 135009741. This is one count failed to display a valid operator's license, not on person. Appearances for the record, starting with counsel, please.
I'm Daniel Wazak on behalf of the defendant. Mr. Walker, please tell the judge your name.
Michael Edsel Walker Jr.
Your Honor, Mr. Walker is here for an arraignment on a bench warrant. We're going to ask that warrants be recalled. And then he has presented to me a valid Michigan driver's license that was issued March 14, 2023, which is basically about a week ago. So I'm pretty sure it's still good.
All right. At this time, I do have in my file a dismissal without prejudice for this particular matter. Sir, make sure you keep and have a valid license with you at all times, okay?
Yes, Your Honor.
All right, if there's nothing further, you're all set. Thank you.
Thank you.
You want to go talk to Tommy Walker real quick? Did you get that offer? And then I gotta bring, we're gonna get Miss, well, hold on for a second. Yeah, call him.
Only one side. No. Is that the only witness out there for the motion? As far as I know. Oh, okay. Wait, there's another one. Also Lawrence. That's all.
All right, Officer McCall. Good morning. Good morning. You can go ahead and come up. Okay. Serena Wims. Mr. Walker can just stay in here. too.
Yes, I'm here.
Okay. Now calling the matter of the people versus Serena Wims. This is case number Z805831. This is going to be one count of operating while intoxicated. We're here today for a review in this matter. Can I have appearances for the record, starting with Officer McCall in the courtroom, please?
Good morning, Your Honor. Myra McCall on behalf of the probation department.
Good morning, Your Honor, to both you and Ms. McCall. I'm Daniel Wazak, P35225. Ms. Weems, will you tell the judge your name, please?
Serena Weems.
I will defer at this time to the probation office, Judge.
All right, thank you.
Your Honor, Ms. Weems was placed on probation on July 23rd, 2021 for 1 year. She was ordered to pay $910 in assessed fines and costs, attend and complete the Victims Impact Panel, attend the Alcohol Anonymous once per week, shall not use or possess any illegal substance, attend outpatient treatment until discharge in writing, view the consequence video, and complete the driver simulator class. And Ms. Weems last appeared, Your Honor, on January 23rd, 2023 by Zoom. And at that time, she was instructed to complete 48 hours of community service in lieu of $460 in assessed fines and costs. She has completed the outpatient treatment. She has viewed the consequence video, as well as completing the Victims Impact Panel. And at this time, she has completed 38 hours of the community service. So she has 10 remaining hours to complete. And also on January 23rd, 2023, at the last review, you indicated, Your Honor, if she complied and completed the community service, that you might entertain discharge, but she still has that 10 hours to complete.
And Sergeant McCall, I forgot, Ms. Sandy's in the courtroom today, so you can face this way a little bit. Listen, I forgot, because I'm so used to her not being in
Right,
here.
I'm sorry. I can hear her fine. Mr. Wazak, you want her to face that way.
Okay,
good.
You can hear her good?
I can.
Okay, all right, I'm so sorry, I'm
No,
so
that's
used to like
okay.
having
That's
to go up
right.
there. That I realized halfway through and didn't want to stop you, I'm so sorry.
That's okay,
All
Your
right.
Honor. Thank you.
Good job, Ms. Wings. How long will it take you to complete those last 10 hours? Because I will consider dismissing you from this, but I do want you to complete all the community service. How much more time do you need?
2 more days, Saturday and Sunday.
Okay. Officer McCall, let me ask this. Is this something that she doesn't need to come back online for, since she substantially completed, and I can just sign a dismissal form for her next thing?
Your Honor.
All right, Ms. Wings, what I'm gonna do is I'm gonna set it out for a month. But if you complete the community service and turn it in to Officer McCall, and she gives me the paperwork, I'll just sign it and you don't have to come back on, okay?
Okay.
Have you learned something from this before I do this though?
Yes, I have.
What have you learned? Tell me at least one thing, ma'am.
I learned that it's dangerous to drink and drive. You can hurt somebody or yourself.
Absolutely. And that's the most important thing. It's not just you out there on the road that you have to be concerned about. It's the other people too that you don't realize you may affect. And once you affect their lives, it affects you substantially. Because I've seen it, Ms. Wynn. I've seen what happens when other people have taken the lives of another human being and they still have to live. How the pressure from the family, how the guilt they feel, and it's just not good. So we got to make sure we keep ourselves right and on track, okay?
Okay.
All right, so it's going to be the order of this court that as long as Ms. Weems completes her community service, Officer McCall can present to this court a dismissal, and I will sign that, and you won't have to come back. If you do not complete it, ma'am, you have to come back and see me on May 24th at 8:45 a.m., okay?
Okay, it's gonna get completed.
I know, I'm pretty confident in that it will be completed. And congratulations to you, since I probably won't see you again. And don't come back to my courtroom, okay?
Okay, thank you.
You're welcome. All right, there's nothing further. That concludes this hearing, okay?
Okay.
Thank you so much, Your
No
Honor. Have a
problem.
wonderful day.
Thank you. You too.
Thank you.
And then, Mr. Tommy Walker, you came back. You had time to talk with the attorney?
Yes, I did.
Okay. Recalling the matter of the people versus Tommy Lee Walker, the fourth. This is recalling tickets number SP 1260680, one count no insurance misdemeanor. Ticket number SP 1260672, one count drove while license suspended. Count 2, unregistered untitled vehicle. Count 3, improper plates. Ticket number SP 1260622. Count 1, dirty, obscure, improperly displayed plates. Count 2, expired plates. Count 3, no receipt of or unsigned registration. And ticket number SP 1116309. One count, improper plates. Count 2, drove while license suspended. Appearances for the record, starting with counsel, please.
Daniel Wozak on behalf of the defendant, Mr. Walker, please tell the judge your name also.
Tommy Lee Walker the fourth.
Your Honor, I'm in possession of a recommendation from Assistant Corporation Counsel. He would like to accept that and go forward.
All right, if that's the case, sir, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Did you have a chance to talk to an attorney about your case and about your rights?
Yes.
Did anyone threaten, force you, or promise you anything in exchange for a plea today?
No, they did not.
Are you pleading guilty of your own choice?
Yes, I am.
Are you pleading guilty because you are guilty?
Yes.
And do you understand that by taking this guilty plea today, that you're going to give up the rights that you had to have a bench or a jury trial in these matters?
Yes, I do.
And understanding all of that, did you still want to move forward today?
Yes, I do.
All right, sir, I want to take your attention back to the date of October 12th of 2021. Were you in the area of Lappin and Gratiot in the city of Detroit, sir?
Yes, I was.
Driving a Chevy vehicle?
Yes.
And while you're driving that vehicle, was your license suspended at the time?
Yes, it was.
Did the vehicle also have improper plates on it, sir?
Yes, it did.
Satisfied, counsel?
Yes, Judge, thank you.
Stipulation for probable cause on the remaining counts to be dismissed?
Yes, we stipulate.
So at this time, the court's going to enter a plea to the amended charge on count 1 to fail to display a valid operator's license, and on count 3 as charged improper plates. The remaining counts called on this record today will be dismissed. Mr. Walker, my fine is going to be $200 on the improper plates. I'm going to waive the cost and fines on the other ticket, and that's only because you owe tickets that are in default. You owe probably about $700, $800 from what I have in the file alone. So I'm not gonna overcharge you. I'm gonna charge you some though. And I'll give you 60 days to pay that, so it'll be due May 23rd, 2023. My suggestion to you, sir, if this is a lot of money that you owe, come down here and set up a payment plan. That way you don't have to feel overwhelmed and you can take care of it in chunks as opposed to trying to come up with this large amount of money in one time, okay?
Absolutely. Thank you so much.
You're very, very welcome. All right, if there's nothing further, Mr. Walker, you're all set. Thank you for signing in this morning.
All right. Thank you.
Thank you. All right. What about Jayla Williams, Attorney Wozak? Did you talk to her?
I did talk to Jayla Williams. She wanted a pretrial to get her documents in order. I don't see her now in the breakout room.
I don't. I'll give her a pretrial date of May 24th, 2023.
That's very kind of you, Judge.
She calls and does it. She was arraignment on the bench warrant, so I'll just set it over to that date. Hopefully she comes in here. I know that she did sign in because they handed me the file.
Right, and I spoke to her, so that she knows what our plan was.
Okay.
So she may call in and say, did somebody give it to me? I lost the meeting. Yeah.
Okay. All right. Did you have other courtrooms to be in this morning, Mr. Wozak?
No, Judge, I'm at your disposal. If you need me to wait a while, I can.
Can you wait until 11? I'm gonna do some more on this matter that I have before me today, and then if no one else signs in, then I'll just let you go. But that way, since you're here, you can just hold on tight for a minute. If Ms. Williams signs back on, I can be able to do her matter.
That sounds great. I'll just mute myself and hang
And
around.
even I'll give you some, well, I want to rain on the bench for it though. Let me tell
Yeah, that's not.
Yeah, all right, yeah. So just wait a moment for me. You can go ahead and do what you need to do, but I just want to see if she signs back.
That's absolutely fair. I'll wait.
All right, cool.
Actually, yes.
That is a subjective description, I just would like to say.
All right. Recalling the matter, recalling the matter of people versus Nakia Wallace. This is Z ticket 808261. One count of interfering with government employee performing their duty. Count 2, loitering, impeding pedestrian or vehicular or vehicle traffic. Appearances once again for the record, starting with the city attorney, please.
Good morning again, Your Honor. Alexis Schneider for the people, P80322.
Counsel.
Good morning, Your Honor. Nancy A. Parker, P number P84325, on behalf of defendant Nakia Wallace.
Ms. Wallace. Nakia Wallace. Are we ready to proceed at this time?
Yes, Your Honor.
And who will be your first witness?
My first witness is our former corporation counsel, Florence Garcia.
All right, thank you. You may. Come here. Right here, we did wipe off the seat for you. Can I have your name, please?
Lawrence Garcia, with a W, LAWRENC.
Hi, Ms. Garcia. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, you can come in. Please, once again, for the record, state your name, sir,
Lawrence Garcia.
and counsel, you may proceed.
Thank you, Your Honor. Good morning, Mr. Garcia.
Good morning.
Now, I know.
May I just apologize to the court? I'm wearing the wrong shoes, but I've got a bad case of plantar fasciitis and I don't like taking the medication, so.
Counsel, you look very appropriate for court today. Thank you for your apologies, but I'm
Respect to the
fine.
court and to the parties.
Thank you so much. I appreciate it.
Sorry.
Okay. Now, I know you are no longer, but did you used to be employed by the city of Detroit?
Yes, I was the corporation counsel from the very beginning of 2018 until the very end of 2021.
And what were your duties as corporation counsel?
Supervising the law department, representing the executive branch of the mayor, the legislative branch of the city council, also representing the clerk, and trying to make sure that the city as an organization had good legal services in all the ways that the city needed it.
Do you work in a supervisory role?
Yes, there were 120 employees out in the law department when I was the corp counsel, and those people would report to me as the head of the department.
As part of those duties as corporation counsel, were you familiar with the protest cases occurring in the summer of 2020?
Yes,
And as a part of that group of protest cases, are you familiar of the discovery issues that arose in the summer and the fall?
probably.
You say probably, what do you
Yeah,
mean?
it depends what you mean in discovery issues. I could explain what I think that means, but maybe I should wait for a closer question.
It's a fair question. So were you familiar that the city was facing motions to dismiss for failure to provide discovery?
Yes. Best I would explain it, there was a large number of arrests made at a pretty chaotic time. And the details that normally go with an arrest were not practical reality. And that created a lot of problems as those cases matured and defendants were challenging what kind of evidence was available to make the case.
So you said that the problem was, is that correct?
Yes.
Were you made aware of those problems by staff from 36 District Court? Or
Yeah, and the police too. We had meetings with leadership from different areas to try and figure out how little or how much evidence we had, and what we could do with the first tranche of cases that were made.
You say the first tranche of cases. We'll talk about Ms. Wallace and her cohort who were arrested on July 10th, 2020. Okay, we'll stick to is that part of the protest. With them, are you familiar that the city was facing motions to dismiss for unfair discovery?
Yes.
opinion as to what the city should do? Did you instruct any board as well?
Well, first of all, I'd like to say that decisions were made collaboratively. That was, I think that's good policy. But yeah, I think collectively, a number of people agreed after some cases were dismissed, it was wise to dismiss the others because we were short on discovery or the ability to provide discovery responses in a large number of cases, including small.
You say short on ability. Do you have any reasons as to why?
Well, like I said, when the arrests were made, it was a very chaotic situation, and I think the police were not prepared to have the arresting officer make the normal kind of record or documentation about the arrest. And so as a consequence, it was hard to link the arrestee to the arresting officer. They were processed through middle people, other officers to put people in buses and had it in a holding area. So all of that translated into a very mixed record of what had happened. And that made it hard to account for exactly what had happened in the prosecution.
And while these discovery issues and criminal cases were pending, are you familiar that there was a civil lawsuit also pending?
Yes.
What is your familiarity with that civil lawsuit?
I worked on it directly. I drafted or co-edited a lot of the pleadings. I appeared before Judge Michelson at conferences and hearings.
Is one of the pleadings that you worked on the city's answer and also included a counter complaint? Prior to that being filed, did you also work on a specific order to preserve the status quo?
Yes. The city, the law department was chagrined that the judges entered an ex parte order in the case without giving us an opportunity to present our side of what was going on. And to try and keep that from being too much of a disadvantage of litigation, we made a stipulation and we also made a counter.
And in your opinion, what did the stipulation in order preserve? What did it do?
Well, yeah, that's the funny thing about the case. As I recall it, the parties never really agreed to do anything other than follow the law, which they should have been under a duty to do even without the case before Judge Michelson. But it seemed, in her estimation, to be a good step towards ensuring peace in the streets, for there to be an open recognition of legal obligations on both sides of the case. And I suppose that exercise was helpful in that protests were less disruptive after that time.
Are you aware that the coalition filed a motion to dismiss the counter complaint in October of 2020?
I think so. The other side of the case opposed the counter claims. And I think there was some buzz in the news about it.
Did you have a chance to read that motion to dismiss?
I'm sure I did, but it was over a year ago.
Were you, just to clarify, you were aware that there was this pending motion to dismiss while you were also dealing with the discovery issue for the criminal case, is that fair?
Yes.
And were you aware that the counter complaint was eventually dismissed in March of 2021?
Yes.
Did you learn that in real time?
Yes.
And because of that dismissal in March of 2021, did you instruct PPP or any of the lawyers who supervised to reissue cases against the federal plaintiffs?
I don't understand the question. You're asking if the dismissal of the counterclaim in the civil suit impacted the criminal prosecution?
Correct.
No.
Did you tell anyone on a criminal case to do anything pursuant to the dismissal of the counter complaint on a civil case?
No, those were two completely separate matters that I would never do.
Are you aware that the criminal case for Ms. Wallace was dismissed in February of 2021?
Not specific to that date, but I know her misdemeanor case was dismissed.
And do you believe that those dismissed? Why do you believe the case was dismissed?
What we talked about earlier, at the time, we had not done the work to see what evidence could be linked to which charge.
And Ms. Wallace was arrested in July of 2020. The case was not reissued until May of 2021. Do you have any explanation why it took so long?
Well, things move slowly in city government, and with word, with the police, and with the law department, a lot of those agencies or offices had to do their work in order to lay the groundwork for a better case the second time around. As I recall, there was a task force or a select group of officers who were put in charge of reviewing videotape footage. There was a lot of that. And then supervisors had to be consulted with, as well as lawyers, to decide which videotapes and which evidentiary offerings would really stand the test in criminal prosecution. And all of that coordination involved a lot of people, a lot of opinions, and a lot of time.
As part of that coordination, did you instruct anyone to specifically target Ms. Wallace?
No.
Did you instruct anyone to target any of the federal civil plaintiffs?
No.
Did you personally look through the footage looking for any particular person, including Ms. Wallace?
No, I think I saw some footage in some cases, but mostly that was down to other people who spent more time studying the matter from the police perspective, what was captured on videotape, what happened at the scene, and then from the law department's perspective, counterparts of yours in the 36th district division of the law department who know a lot about how we prove a case in this courthouse.
You said there were conversations about the cases being reissued, right?
Yes, collaborative discussions to reach conclusions about what was prudent or wise.
And how did you decide on your part which cases should be reissued or should not?
By the evidence, the cases that the police felt had the most evidence to support and the lawyers felt had the right elements to be capable of getting a conviction.
Were there some cases that were not reissued?
Oh, yeah,
Were some of those for the federal plaintiffs to your knowledge?
I'm sure. As I recall, there was like 120 in the original bunch of arrests and dismissals, and then it was like a dozen that were recharged.
For the recharge, how was it determined what exactly the recharge was?
Again, the 36th District Court experts, colleagues of yours in the law department who knew the law about misdemeanors better than people like me advised, and we took the advice.
Do you specifically try to increase or decrease charges for the person?
No, it was about what the evidence would sustain.
Nothing for your honor.
Thank you. Cross-examination?
Thank you. My name is Nancy Parker. I don't believe we've met before.
Good morning.
Good morning. Thanks for being here today. So, Mr. Garcia, you just talk about these collaborative meetings about the recharges.
Yes.
Can you tell me who was all part of those conversations?
I don't think it was always the same people. I think definitely Doug Baker was in town. Probably everyone out of it. Doug Baker was the supervisor for the 36th district team. There was a lot of, he was an important part of this collaborative.
Would Shannon, I'm sorry.
Yeah, I think Shannon Walker was in a number of meetings. On the police side, I want to say Todd Bedison was in several, but I think there were also some high-ranking police officers that were below him, and not as well known to me. I might just be remembering him because I knew him better.
Understood. And can you tell us when did those collaborative meetings start?
I really don't know the calendar. I'm horrible with dates, but it was between the dismissals and the recharges, closer to the dismissals. And like I said, there was a number of meetings over a series of months to try and reach decisions on which cases would be worthy or capable, we could recharge them, improve.
And when you say dismissals, which point in time are you referring to? Are you talking about starting in January when Judge Williams dismissed about 50 cases? Or are you referring to when the city unilaterally dismissed cases? What point in time are you referring to?
Well, because as I remember, those things happened pretty close together in time. I know that there was a 36th district court judge, I don't remember the name, but I trust your memory better than my own. We dismissed some, and then we dismissed a bunch because we saw that it was gonna be a problem. We were gonna run into the same problem.
Okay. And in dismissing a bunch, you didn't dismiss all of them, did you?
Don't remember.
Okay.
It would have been the vast majority, if not all.
And after the vast majority were dismissed, there were still some continuing cases, correct?
Yes.
Okay.
Those were cases where we felt the evidence was strong.
And so, Mr. Garcia, let me direct you specifically to my client, Ms. Nikia Wallace's case. It's a July 10th arrest from 2020.
Okay.
Is it your testimony today that no collaborative efforts took place, no attempts to obtain information took place in terms of video camera, trying to piece together what you call a chaotic event in terms of body cams? Are you saying that no discussions, no collaborative efforts took place until after February of 2021?
No. So there's
You said after the dismissals, correct?
Right. There's a lot of things that were happening at the same time. There were the criminal cases first, and there was the civil case. After the civil case was filed, we looked for videotape of the civil plaintiffs. Reasons being, we wanted to examine the strength of their case and figure out our defense in the civil action. And some of that work, or some of that videotape, was valuable in some of the criminal cases because there was an overlap of the people involved. Some of the plaintiffs in the civil case were also defendants in some criminal cases. So that review of videotape was done way earlier than the review of videotape and evidence that was done after court decided dismissals and prosecution voluntary dismissals.
Thank you, Mr. Garcia. That is a great point. You are saying that Ms. Wallace, as a named plaintiff in civil litigation that was filed in August 31st, that because she was a named plaintiff, she would have been one of those criminal defendants in which the law department was looking for evidence on. Isn't that correct? Isn't that what you just stated?
No, not in those words. So, as I said, the review of the civil case involved looking at videotape of what happened. And in some cases, that gave us something to talk about when we were looking at the criminal cases. The purpose of the review of the video was not for the criminal matters, it was for the civil.
Right, understood. So following that train of thought, in the review of the civil case and the plaintiffs there, did anything bear fruit that was useful in the criminal?
I don't know about bear fruit, but we found videotape that we wanted to use in our analysis of criminal matters and whether they should be dismissed. We used that as part of the decision process for figuring out which cases should be voluntarily dismissed and which cases should be recharged after voluntary dismissal.
Mr. Garcia, I'm kind of be real, like nitpicky with the timeline, but the timeline is very important here. So the federal case was filed August 31st. The TRO was entered September 4th, 2020. Does that sound right to you?
Yeah, I don't know the dates, but I think the order is certainly sound.
Okay. And so during that time period, was that a point in time where you as lead on the federal litigation, was that time frame I just gave, we got August 31st, we got September 4th, city filed this answer and counterclaim on September 25th. During that time period, you have 9 named individual plaintiffs. Are you doing that work that you just described of looking at of video footage?
Yeah, I would say within the first 4 or 5 weeks of getting the complaint, and the TRO, I had assessed the claims by doing a lot of things, including looking at video.
And Mr. Garcia, if you were to have come across videotape either from drugstore city surveillance or body cam footage, that would have been something that you would have brought to light to your team and to the team that was handling the district court matters, correct?
Yeah, if it bore on the question, again, two frames of mind, 2 different analyses. The first was how to defend the civil claim. The second was, what do we do about these criminal cases? Can we prove them? Can we follow them through to the end? And so we may have found video in the first endeavor that was relevant to the second. And when I did, I would have brought it up. And I think others as well. I don't think I was the only one looking at videotape for more than one purpose. And we were trying to make smart decisions. So we were telling one another what we thought the pros and cons of each decision was.
And in making these prudent, smart decisions and speaking with your colleagues, was Shannon Walker one of the people that you would have been having these conversations with?
Shannon was in the room a lot. She was, I think, here in this building a lot, and we would tell her what had been gone over. You know, I think she heard about a lot of things more after the fact, but I don't think she was actively involved in the discussions that actually produced most of the decisions.
Okay, thank you, Mr. Garcia. That's very illuminating. Can you then tell us who the lead counsel or team that made up the district court matters, the criminal cases? Were you also heading that and the federal lawsuit, or was that a different head?
Well, the buck stops with me. I was the head of the department, so I don't want to shirk any responsibility for the decisions that were taken. But I also don't want to claim to be more knowledgeable or expert than I would have relied on advice and judgment from Doug Baker and Shannon Walker quite a bit. But I'm not saying they took decisions without, I'll take full responsibility for all decisions made. But yeah, I think you get it.
Understood. And in the reissuing of tickets after they had been dismissed, were you leading that process?
Again, under my authority, I take responsibility. I think Doug's probably more knowledgeable about the details, but it was, yeah, it's my team. He was under my supervision.
And do you recall that over 400 protesters were arrested on various days during the summer for the BLM protest?
I don't remember a number of that.
Do you recall the caseload being over 400, if not the protesters, the matters, the cases being over 400?
No, I'm sorry. No, I thought it was closer to 130.
Oh, Mr. Garcia, that's woefully undercounted. I think there's plenty of evidence to show, I think even in.
Hey, look, I'm not arguing with you. I'm just saying that that's not my number. Some of that might not have been known to me. I'm not saying it's wrong. I'm just saying that the cases that I knew about and talked about were a smaller number than the number you mentioned.
Fair enough. All right, so using my estimate, which has been the number that we've been using consistently for the 3 years this transpired, or over 400, excuse me. Can you tell us, do you have a recollection of how many cases were reissued of that over 400 cases?
Objection, Your Honor, he doesn't agree with the 400, he couldn't possibly guess.
Right, I was about to say, did you want to have a response?
I'll rephrase.
I'm gonna sustain her
No,
objection.
I'll rephrase it. Mr. Garcia, of the hundreds of protesters that were arrested, do you have a recollection of how many you authorized the reissuance of charges?
As I testified to earlier, I believe it was a dozen and a half. 12, 18 cases reissued.
Okay. And of the plaintiffs in the federal case, do you know if everyone who's, strike that, of the plaintiffs in the federal case, are you aware that all the plaintiffs who had existing criminal cases, that their cases were refiled?
No, but it wouldn't surprise me.
And you recall that the majority of the plaintiffs did not have criminal cases, correct? In the federal.
I thought it was about 50-50, but if it was less than that, I wouldn't have a strong basis to disagree with you. I think, to me, it was closer to even. I think you said there were 9.
There were 9 individuals.
Right.
There was
There's an organization too, right? But yeah, I would have thought it would be like a 4 or 5 split.
So it's true, or you agree that there were plaintiffs who did not have any underlying criminal cases, right?
Correct.
All right. So I'm just trying to clarify, the testimony earlier made it seem as if that there were plaintiffs who had criminal cases that were not refiled, but that is not the case, correct?
I don't know.
The record is clear on that, so I'll move on to that point. So, Mr. Garcia, going back to the motions that have been filed in the criminal cases, you were aware, as you have testified, that defense counsel filed a motion to dismiss based on lack of discovery, right?
Yes, as I recall, there was some like consolidation representation. There were a number of criminal defendants, misdemeanor criminal defendants who had gotten together with 1 or 2 lawyers and presented like a brief motion.
Right. And when that motion was presented, is it your testimony that you had already looked at video evidence with your collaborative group in conjunction with the federal case in August, September?
No, that was pre the task force phase, which is the second phase I was talking about when the police department brought a lot more to bear to the analysis of videotape and searching for evidence that would sustain charges. The point when the motion was made and cases were dismissed in 336D, we still had not begun it. We hadn't done it.
Do you know about when the task force was formed?
No, it was within 60 days of the dismissal promotion. Roughly. I don't want to say 60 or not 61, but around.
Understood. And Mr. Garcia, at that point in time, how long had you been practicing law?
2 years.
22 years. All right. And is it customary for when there's a pending motion about discovery for you to not do that investigative work during the pendency of the motion? Is that something that you would regularly do?
I don't understand the question.
I'm trying to understand why it wasn't until the formation of the task force within about 60 days after a dismissal, which occurs in
Sure.
February 21. I'm trying to understand why you, as a, experienced attorney, did not do due diligence for that same process of discovery while there was a pending motion on the exact matter.
So I think I understand the question better now. I think I can answer. From the beginning, the point of these criminal cases was to try to create a distinction between lawful protests and impermissible civil disobedience, assault on police officers. I think, as I told you, the large number of arrests grew out of conditions that were very chaotic and hard for the police to control. But they made arrests, and we wanted to support the decision making they had in the scene by trying to make those cases where they had made arrests. It proved difficult to do that. And when we couldn't make all of those cases, the question was whether we could make some cases to nevertheless enforce the law and demonstrate a distinction between what is acceptable behavior and what is criminal behavior in this context. And so, the large number couldn't be supported, but the smaller number, after studying the issue with the benefit of time, hindsight, videotape review, was a different calculus.
So, Mr. Garcia, you keep referring to it as a chaotic situation. That UPD was not prepared, but it was only a chaotic situation based on UPD's response, correct?
Your Honor, there's no relevance as to the prosecutorial discretion of the.
I'm sorry, just want to keep your voice up, please. There's no relevance as to the
Prosecutorial.
Your Honor, I'm trying to get clarification from Mr. Garcia that said multiple times on the record that the reason that they didn't have this evidence, which is what we're here about, is because it was a chaotic situation. So I'm asking him about the chaotic situation that led to the lack of discovery, which is why we're here.
I don't know if this is the right witness to ask this to, but I'm gonna give her a little latitude to see. You weren't out there that day, Mr. Garcia, were you?
Correct.
Okay. All right. So you can ask him the question. I don't know if this is the right witness to get that. He's using that term, I understand, but you can ask him for clarification, I guess, of what he means by chaotic. So I'm gonna overrule you at this time, but.
Yes, Your Honor. Thank you. Mr. Garcia, can you explain why you believe, try that, let me preface by saying, these were, try that, let me ask a different question first. You mentioned that you needed to differentiate between lawful protest and illegal activity, correct? Something of that nature?
Yeah, there was a lot of demonstration happening in the city of Detroit that summer. Relative to the activity, there were very few incidents that caused arrests. And what I'm saying is, it's great that there could be so much public demonstration and so little arrests worthy, what the police deem to be arrest worthy activity. But that arrest worthy activity needs to be examined and enforced, have a law enforced on that in order for the city to have a chance of a similar future where most of demonstration would be peaceful and some demonstration less so.
Right, and so is it accurate that you were saying the majority of the demonstrations were non-violent protests, correct?
Globally, across the whole summer, yes, overwhelming.
Yeah, and specifically to my client, Ms. Nakia Wallace, was she ever charged with any assault?
I don't remember, I'm sorry.
Do you recall about how many protesters, if any, were charged with any assaulted charges?
No.
You don't have a recollection?
I thought the overwhelming majority of arrests were for disorderly conduct. That seemed to be like a catch-all for the cops. And they didn't really have time to think for something better.
So disorderly conduct was a catch-all offense, you're saying, that was
Yeah,
charged?
I think that was the most common go-to charge when things were happening very fast.
Things were happening very fast and the police didn't know what to charge, or the police didn't know what was going on?
Yeah, I mean, you pull somebody over, there's a lot of time to think and reflect, and it's different from grabbing someone off a skirmish line and putting them in cuffs. And I think that's what I'm describing, is that I'm trying to deduce why there might have been so many disorderly conduct charges as opposed to other flavors of charge. It seemed like police were regarding that as a broad charge that they could use in a lot of different circumstances.
And in your experience, and specifically in your role as court counsel, was it your experience that folks had been charged when there was a witness, be it an officer or an individual who observed and witnessed a crime?
Your Honor, I just would like to inform the question. Does she mean every crime he knows of? Does she mean Miss Wallace, summer protests?
This goes question. You want to take it piece by piece?
Sure, we can break it down, Your Honor.
Sustain her objection. Just take it piece by piece, asking the question.
No problem. So, Mr. Garcia, in your role as court counsel, I assume you reviewed the charges that were brought, correct? In general, I'm saying your role, your duties as court counsel,
Which charge?
criminal charges.
No, I mean, I would say 99.9% of criminal charges brought to the city of Detroit do not rise to the attention of probation.
Okay, thank you for that clarification. In the instances where there is a criminal matter that bears your expertise or your advisement on, has it been the case that in those circumstances, when an offense was charged, there was a complaining witness, be it an officer or an individual?
Yes.
And to put another way, have you ever been privy to a case where charges are brought, but there is no identifying witness of the alleged offense?
Right, well, yes, and I think the summer that we're talking about is the example that an officer would make an arrest, hand off the arrestee to another officer who would create paperwork for the citation and process the arrestee. And in that exchange, the witness who saw the arrestee doing the thing that the arrestee should have done wasn't able to download the information to the officer who created the paperwork. And that process was problematic for us because it did not create the kind of record we're used to having to sustain a case with criminal prosecution.
And thank you, that goes back to my previous question, it's that process that DPD carried out is what you're referring to when you say it was a chaotic situation, I think was your verbiage.
Well, the reason I'm talking about chaos, ma'am, is not to excuse bad behavior, but to describe a practical reality. As it was explained to me by police officer supervisors during that summer, there had never been protest of that dimension in the city, certainly not during the lives of the living supervisors. Protests that large go back decades and generations ago. So the city was off balance or on the back foot in trying to respond to a new kind of concern. They got better at it through the summer, the police that is. But in the early days, for sure, there was no system discussed and rehearsed in advance that would allow arresting officers to make a clearer, better record than the records that were made. And so what I'm trying to explain to you is it's not anything to celebrate, but it's a practical truth that officers were arresting people and not creating paperwork themselves in the beginning stages of the response to the demonstration. And my excuse for that, my reason for offering why that happened that way is because the response was novel. This was a new problem, and the police department was not equipped or prepared to do things better than they did in the first period of time.
Understood. And with that, Mr. Garcia, it's still the case that you knew in the time that the process was flawed, but the collaborative effort to actually review the evidence didn't occur until February of 21?
I wouldn't make that a blanket statement. I don't know that that's true. I've told you what it was like from my perspective, but you're opening my eyes to the fact that there may have been hundreds of cases that I didn't know about. So I don't know what all everybody else did to review the other criminal cases. I'll just tell you about the ones that I was part of.
And specifically to my client, Ms. Nikhil Wallace, you were part of that team, correct? Because she was a named plaintiff in the federal case.
Not because she was a named plaintiff in the federal case. Her case was brought back by the task force that was reviewing videotapes as a case, among others, that would, in their view, sustain a charge or be proven.
Well, Mr. Garcia, I thought you said that you looked at cases where of the named plaintiffs to assess the civil case and contemporaneously assess the criminal charges, correct?
Yes. I'm
So-
telling you, there were multiple videotape reviews. You know, and I think you can't lump them together. Different reviews were conducted at different times for different purposes. But it is true that I and other people in the law department looked at videotape of Nikhil Wallace after the civil suit was filed and before the task force was formed, because we were assessing the civil suit. And we didn't forget that we had done that when the dismissals started happening in this court. We remembered that we had done that. We remembered the video.
Thank you. Okay. Moving on slightly. Were you aware that Ms. Nikhil Wallace was leading this protest and was a founder of the organization Detroit Will Breathe?
I'm sorry, Detroit, what?
Detroit Will Breathe.
I may have known that at the time, but I don't remember that.
And sometime in the summer, after a couple of the demonstrations, there was a meeting that was held between the city and my client, as well as fellow plaintiff Tristan Taylor. It included the mayor, the police chief, and there was someone there from Corporation Counsel. Was that you?
Sound familiar to me?
Were you briefed on that meeting that Ms. Wallace and Mr. Taylor had with the
Doesn't
mayor?
sound like that. I don't think so. I don't think I've ever heard of it. When did it happen?
It happened in the summer after probably about a couple of the demonstrations, so it would have been early June.
days?
Maybe.
No, I don't think.
Mid-June?
I don't think I knew about that until just a
Okay. Were you familiar with Nikhil Wallace's name from any of the print media, radio?
Yes.
Can you speak to what you knew of her from those media?
She was one of the more visible, vocal people in the coverage of the demonstrations. There was a two or three others. Can't remember.
Tristan Taylor?
That sounds very familiar.
And in your role, do you collaborate a lot with the police chief?
No.
Were you aware that he was making a lot of public statements and giving interviews where he was blaming Detroit Will Breathe and Nakia Wallace and Tristan Taylor specifically for violence?
Your Honor, I object to that question. It doesn't matter what former chief does.
It's outside the scope, and I don't know that he should testify to that, so I'm going to sustain her objection at this time.
That's very right. I would just like to say that it's still going to vindictiveness. I'm trying to lay more evidence that they were aware of Nakia's activities, they knew who she was.
He said he knew who she was. He said he even knew who she was from the media prior to this. So he said he had knowledge of her. As I understood the question that you just asked, it was about the former chief and whether or not he wouldn't have knowledge to whether or not the chief was trying to get back to him. So I'm going to sustain her objection at this point in time.
Okay, I'll move on and maybe it will come to light as I ask other questions. So was it your decision to file the counterclaim against my client and the other claimants?
Yes.
And is it accurate that that counterclaim in essence was claiming that there was a civil conspiracy by Nakia, Detroit Breed, and the other plaintiffs to enact violence against DPU?
I wouldn't put it like that.
How would you put what the counterclaim was saying?
I would let the counterclaim speak for itself. It's been a long time since I looked at that document. I wouldn't try to recreate it.
All right, but you did draft it, correct?
Yeah, I mean, I think it went in under my P number. I think I was first chair in the case, yes.
Can you give, just from your recollection and you being first chair on the civil rights suit against the city, just general, what was that counterclaim about?
So I'm kind of going inside baseball here, but I want to be fair to your client and be as candid as possible. In any civil litigation, you don't want to lose the momentum with the judge, the court. And when we found ourselves facing a TRO ex parte, we kind of felt like we were behind. We were losing the game, losing momentum. So the purpose of the counterclaim was to explain to the judge the other side of the coin, that whereas the plaintiffs in civil action felt the police had violated the law, the police felt the plaintiffs had violated the law as well, at least some. And that those activities needed to be addressed by the court, along with the activities that the plaintiff wanted the court to address. Counterclaim was successful in the sense that I think we did open Judge Michelson's eyes to the nature of it being a coin with two sides, which was civil action. And the order that was entered was even-handed in that it restrained both sides from illegal activity instead of the original TRO, which was just one side. So the purpose of the counterclaim was to balance the narrative of the story that give the court appreciation of the needs and interests of the police department as a counterweight to the needs and interests of folks interested in civil demonstration.
And is another way to put that from your pleading was that the protesters / the named plaintiffs engaged in a concerted civil conspiracy?
That sounds familiar. I'd let the document speak for itself, but I do think that might be part of the phraseology.
Okay, thank you. And you said that you feel like the counterclaim was successful, but isn't it true that Judge Michelson dismissed your counterclaim with prejudice on March 10, 2021?
I don't know the date, but yeah, it was dismissed. That's true, but it doesn't discount the point I was trying to make. The purpose of the claim, the counterclaim, was to demonstrate to the court that there was another side to the story.
And it was dismissed with prejudice, right?
I don't know.
Were you part of the team looking at the named plaintiffs in the civil case? Did you review footage for the other named plaintiffs whose charges were reissued, specifically Zach Colzay, and Dr. Brian Silverstein.
I don't remember.
You stated earlier that you were familiar with Ms. Wallace's news. Did you have an opportunity either from the media or when you were reviewing evidence at any stage that you said you did so? Did you see the viral footage of the DPD officer putting Nikhil Wallace in a chokehold?
I've seen the videotape of the arrest. I disagree with your characterization of the joke.
Michelson and her TRO and subsequent SIP ordered DPD to cease using among the list of violent tactics, but chokeholds is one of them, right?
Chokeholds have been prohibited by the DPD since Barack Obama was president of the United States.
Right, that's not the question. I said in the TRO though, Michelson specifically said cease and desist, stop DPD using chokeholds, correct?
That sounds right, but I would let her order speak for itself. I don't remember with that level of particularity.
So moving to the current pending charges that we're here for Ms. Wallace, you said blanketly DPD couldn't do too many things at once. They didn't know what was going on, so everyone got disorderly conduct. Generally, that was your testimony, correct?
Not exactly, but I know what you're referring to.
Okay. And so subsequently, Ms. Wallace was charged with 2 different offenses. That is impeding government officials, interfering with government official duty, and loitering. Is that correct?
I don't know, but it sounds like that might fit.
At the time when those offenses were reissued to Ms. Wallace, was that part of the decision that you made? Did you have a vote, I guess?
Yeah, I think more likely than not. I think more likely than not, Doug Baker would come and said, out of all the meetings we've had, here's where we're landing. These are the names, these are the charges, what do you think? And I would have said, yeah, Doug, that sounds right to me, go for it.
Okay.
That's the best I could tell you what I think happened. It was a long time ago, and I don't remember it specifically, but that's kind of the way I remember things like that go.
Understand. So Doug Baker would have been the one who presented the idea and you just kind of signed off on it?
No, I'm taking full responsibility. It was under my supervision, but I'm saying Doug might remember more about the precise charges and why they were charged, because I think he studied that more closely than I did, but I approved it and I stand by it.
And for clarification, Mr. Garcia, I'm not trying to undermine your authority or slight what you did. I'm simply just trying to understand who was making the decisions. And so you authorized it.
Yes.
And you as the head take full responsibility, but I'm literally just trying to understand the people involved. And so it sounds like you're saying Doug Baker was the main person.
Yes, more so than I.
Okay.
Yes.
Thank you. One moment. You may. Thank you for the introduction. Mr. Garcia, who else was part of the team? You mentioned this collaborative team of folks. Clearly, we've established Doug Baker. You mentioned high-ranking people. I think you described it in DPD. Who specifically? Was Chief Craig, was he in the room?
No,
Your Honor, I object to this line of questioning. Prosecutorial and Dick is the only people in this room who have the ability to exercise prosecutorial discretion or like myself. The police don't have that kind of discretion.
She's just asking, it sounds like you're just asking who was present for this meeting. And so I'm gonna overrule your objection. She can ask who was present. If it gets to asking what people said in that room, then that may be a different objection, but she can ask who was present in the room for these meetings that we have to try and establish. She's trying to establish who was in there, who may have collaborated. Stuff I mentioned several times about a collaboration. She's trying to establish who was in that room. So.
sure. To be fair, it wasn't like we said, every Wednesday at 3 o'clock, we're gonna convene the same people, in the same room, talk about the same agenda of concerns. That is the opposite of that. It was several different meetings, spread out over months, not on any schedule, and the people attending the meetings changed. But the point of that was to task the police with determining what are your best cases? What are the cases that have a link to videotape evidence or other evidence that will allow us to say the arrested person did this? We know they did this because we have evidence. And then those folks might not have been the same police representatives who came back to report out what they had found. And I don't think it was just 2 meetings, one at the front, one at the back. I think there were several because it took them a long time to get through all the things that they wanted to look at. And it wasn't always the same police officials. I know it wasn't the chief. I remember, I know what he looks like, and I would remember having seen him that summer for this purpose, but I didn't. I think it was different folks above the rank of captain, but I don't remember who specifically, other than I think maybe Ty Edison was in one of these 7 meetings.
Okay, so we have Todd Benson, possibly some other folks, yourself, Doug Baker. Would there have been a paralegal or an associate from your office?
I think so at one point or another. I just don't remember who. I do, it feels like it was more like 6 people rather than just 3. So I think there probably was another person who's helping. It might have been, I don't know.
Okay, fair enough. I don't want to speculate. So Mr. Garcia, you said it wasn't a bookend. It wasn't one meeting in the beginning, one meeting in the end.
Right.
It was all throughout from time of arrest to this.
No, from the time that we decided to examine whether we could recharge anybody, and if so, who. We had this bunch of cases had been dismissed, a bunch we had voluntarily dismissed. And we decided, are we just out of luck? And none of these cases can be made, can any of these cases be made? And the police were first in the process to try and figure out the answers to those questions. And they talked with people from the law department so that we could see, had they come up with good stuff or was it bad stuff?
And so again, Mr. Garcia, for clarification, I keep hearing you say 2 different things. You're talking about these meetings that started post dismissal, but you testified and it is your testimony that there were meetings prior to the dismissals about evidence, correct?
Very different character of meetings.
Okay, and so in the meetings that you did testify to, where you say we have a civil case, we have named plaintiffs, so we're looking at the evidence. Who would have been in that collaborative meeting?
Just people on the caption. The whoever was listed as attorneys for the city of Detroit. And I don't know who else worked in that case. We might have had outside counsel, but that's who would have done the civil suit.
Okay, and in doing that analysis, there was the review of videos and other evidence.
Yeah.
And you specifically, either you or someone on your team were requested said evidence from DPD, correct?
I don't remember how I got it, but I got a lot of DPD body cam footage, and I looked at that.
Thank you, sir.
Yeah, it's probably from DPD.
Understood. So now, I understand that was a civil collaborative team. Going back to the post-dismissal, I think you referred to it as a task force collaborative team.
I think that's the police one-day task force. Yes.
Okay. And you don't, do you have a general idea of how many times you guys met?
No, 2, 3, and 6.
And was there a set agenda when you met?
So what?
A set agenda?
No. I mean, the question was always the same. What cases can we make?
And was it like an ad hoc spur of the moment meeting, or were they?
Oh, no. I'm sure people had a schedule.
Do you know who would have scheduled those meetings?
For me, it would have been Nancy Goldbaum.
And was there, to your recollection, any catalyst or actions in time that spurred those meetings? Meaning, did something happen in a case where you're like, okay, we need to now come and meet, or?
As I remember, it was always when the police thought they had gone through enough to warrant a new conversation. So they got to a natural end in maybe 300 videos, or 25 videos, or I don't know. They got to some point where they had gone through this level of investigation, and then they wanted to talk. And then they had to go back and do another level, or maybe another set of people. I don't know how they divided their work, but it seemed to be when they finished one chapter of their work, we talked, and then there would be other chapters.
And specifically, exactly what you're describing right now, who would have been that point person that you were communicating with that said, we finished this chapter of our work, Lawrence? Who was that person?
I don't know. I probably was kind of late to the party. I think Doug might have been the person that was contacted first from the law department side. And then I would be pulled into the meeting as, hey, they got more for us. Let's see what they have to say.
Understood. No further questions, John.
Mr. Garcia, you talked about the preliminary review of footage for the criminal case, right?
Sorry.
You talked about a preliminary review of some video footage in the civil case, is that
Yes.
correct?
Yes.
Okay, and as part of that preliminary review, did you look through all of the body camera footage available from that date on July 10th?
No.
Okay, was that later done by the task force?
That's my understanding. Yes. That's certainly what we asked them to do. Right.
And when you did that preliminary review for the civil case, were you reviewing it in the criminal context?
No.
Were you looking at possible criminal charges? No. Were you thinking about the possible reissuance of criminal charges?
No. Those are two separate things. A lot of people have tried to push them together. I resent that. My job kept those two things separate.
To be clear, as part of that separation, do the teams on the civil and criminal case work out of different offices?
Oh, yeah.
Do they work out of different buildings?
Yeah.
Do they have different supervisors?
Yeah, I mean, litigation is different from witnesses.
You stated earlier that talking about the chaotic scene at the time of the arrest, remember that?
Yes.
You said that there was not a system. Do you know if the system was eventually created?
Oh, it was. No. And I think it was created in iterations. I think it was improved over the course of the summer. But I was speaking more globally that, especially with regard to the earlier arrests that summer, it was not ideal in terms of being able to recreate after the fact what had happened. It was a pretty big mess, but that got better.
I want to clarify your thoughts about the counter. You told sister council earlier you felt it was right?
Partially, yeah. I mean, wasn't a home run, but we at least got the first base.
And do you feel that you, through the stipulated order, through the change of Judge Michelson's order, do you think that the city's aims were accomplished?
Some of them, yes.
Okay, did the eventual dismissal of the counterclaim, did that lead you to decide to charge Ms. Wallace personally with additional charges?
No, as I said, I wasn't going to handle the civil case any differently because the criminal cases, criminal cases any differently because the civil cases. Criminal cases were about enforcing the law. The civil cases were about defending the city's police practices.
You stated earlier several times that you are the as court counsel, you're the lead attorney, the law stops with you. Is that fair to say?
Yeah. It did when I was court counsel.
Right. As corporation counsel, why did you decide to authorize the issuance of charges against Ms. Wallace?
Because the activity that occurred in the city of Detroit, in the summer we're talking about, was for the most part one perfect demonstration of American First Amendment rights. But there were some exceptions. It was important to me as the person charged with criminal enforcement in the city of Detroit to try and make some cases that would illustrate some forms of protest are not acceptable in the city of Detroit because they're against the law.
Is that why you chose to authorize the charges against Ms. Wallace?
Yes, that was my answer. I wasn't clear. Yes.
Do you believe that the evidence supported that there was probable cause for the issuance of those charges against her at that time?
Yes.
And just that last question, you stated earlier, you talked about there being the criminal task force done by DPP, probably sometime in February 2021. Remember that?
Yes.
When the cases were dismissed, or the criminal cases were dismissed with discovery issues, was the understanding at that time the cases were on forever?
No. We always knew we could recharge. Again, Doug was much more expert on that than I, but we knew that it was not a one and done. That's part of what made it easier to let go of so many cases.
Nothing further, Your Honor.
Thank you.
Okay. If you want to do a redirect.
No, I'm sorry, Your Honor, you said you had a question.
I do. I have a couple of questions for you. First, the original tickets that were filed by DPD office, I know typically for misdemeanors, they don't have to come through. Do they have to, were these tickets that came through the city attorney's office originally for their charges? You get what I'm
For the
saying?
selection of the charges, no. I know that the paperwork was created on the street and somehow pinned to the arrestee as they went to LCA and they were released.
So, let me ask this, are you familiar with the courtroom process for the ticket? You can answer yes or no. Okay,
I wouldn't claim that kind of.
okay. Would this be a better question to ask a police officer than?
Probably. I just know some police officers explained to me why we didn't have better records. And what I've said today is my best attempt at repeating that description, which made sense to me when I heard it.
Okay, I just didn't know if this was a special case where, and I'll give you an opportunity to ask questions based off of my question. I didn't know if this was a special case of, they submitted something to the prosecutor's office or the city attorney's office originally, or did they hand out these tickets and as they were being sent over to be housed? Do you know?
I know they didn't send it, but I think there were some phone calls to people in Shannon's office saying, Shannon, it's a madhouse. What do we do? And she might have advised on what were the options. But I don't know that happened every time. I doubt it. It might have happened some nights or days, but I don't think it happened every time there was a standoff between police and police.
For the record, can you say what the TRO stands for?
Temporary restraining order, and it's distinguished from a preliminary injunction, which is after both sides have appeared in the case. So the TRO can be just one side, which it was in the civil matter we've been referring to today.
And then it was 9, if you recall, or not, it was 9 people on the original federal charge.
Don't remember, but that number sounds right. If it wasn't 9, it was 8 or 10, or it was close to 9. It wasn't 9.
And from what I get, I'm trying to get clarification. From what I get, not all of those people were originally charged.
Right.
Okay.
Right. One lady had a broken hip, and I think the allegation was that an officer knocked her down. But she never had any like interaction with police other than getting knocked over. So some of the cases were like that, where they said it's not that the police were engaged in the back and forth that violated their rights. It's that the police were shooting non-lethal rounds, and that hurt somebody, or pushed somebody. It was tear gas when it shouldn't have. And so not all of these plaintiffs in the civil suit would have been people to claim any particular entanglement with an officer.
And my last question, it sounds like, because you said, if I was correctly, about half of them have been charged with civil matters, correct? I mean, criminal matters.
Right, I think half of the civil plaintiffs were charged, and around that number were charged again.
Do you have any questions based off of what I asked?
I was going to say, I think those questions, your earlier questions, Shannon Walker.
Okay. Any questions based off the questions I asked?
Yes, Your Honor, and I apologize. I do had a couple really just small.
I'll give you some time.
Thank you. Mr. Garcia, so you made the point to say that in the early stages, preliminary stages, when you were reviewing footage based off defense of the federal civil litigation, that you were doing that from the civil point of view.
Yes.
Right.
Yes.
But you also said that you heard that there were some outliers and that it's your job as court counsel to prosecute people who violated the law. Isn't that correct?
Yes, and I can explain, I believe it was Ms. Wallace's case where we would have said, in the civil review, here's what happened. I saw it, and I said, I think we can defend that claim. It doesn't look like what the civil claim accuses it to be. That's very defensible. I see it differently from the way Ms. Wallace did. And then when we were in the frame of mind of examining what criminal cases could be charged again, because the proofs were better, I'm sure Ms. Wallace came up as an example of a case where we knew we had evidence better than a ticket that we couldn't connect to an arresting officer. So that's how I'm saying the awareness, going through the exercise of analyzing the civil claim might have been helpful in the early phases of figuring out which cases we could be charged, because we knew a little something about what had happened to get the arrests.
So, Mr. Garcia, that makes perfect sense, and I understand that. What I'm struggling with, and I mean no disrespect when I ask this question, are you saying that you wear one civil hat when you're doing legal work, and you take off that civil hat and then put on a criminal hat when you want to do criminal work?
Yes, ma'am.
So when you were reviewing that footage or the evidence, and you said, oh, we can vehemently defend the case that Nikhil Wallace has brought, and knowing that that was a pending motion to dismiss her criminal charge based on lack of discovery, your testimony today is that it never crossed your mind, it was never something you would do to inform the criminal side that, hey, I think we can vehemently defend against Nikhil Wallace, therefore you guys have a smoking gun case. You never made that cross from, I have the evidence, here it is, when folks were asking for it?
Yeah, I don't understand that question, but I can offer this that might be responsive. I'm really particular about when I sit down with a client, which client I'm sitting down with, whose interests I represent. When I sit down with a client, I'm very particular about what matter I'm working under for that client. And if I'm presenting a case or prosecuting a case, I'm very particular about what are the elements of that particular case. In the civil suit, the police brutality 1983 charges have one list of elements, things you have to prove to make the case, or things you have to disprove to defend it. And in the criminal context, it's a very different set of things that must be proved in order to make the case. Sometimes there's an overlap. And one element from one side of your work could be evidence in another element on the other side of the work. But I never engage in trying to manage one case with another case. They are separate, and they should remain so, so that each case can rise and fall on its own merits.
Mr. Garcia, I understand you work someplace else now, correct?
Yes.
But as corporation counsel, your client was and always was the city of Detroit, correct?
Correct. But that's
All right,
not a
so-
simple thing to get your head around either, because the city of Detroit has a lot of parts.
Correct. But your job is to defend the city of Detroit, to bring cases for the city of Detroit, correct?
Yes.
All right. And so you testified earlier that you knew that the coalition of defense attorneys filed a motion to dismiss based on lack of discovery, correct?
That's my understanding of what they did, yes.
Okay. And for clarification, again, it's your testimony that you specifically never went to Doug or anyone or yourself being the head, and you said the buck stopped with you, and said, we will prevail on this motion to dismiss because I have viewed footage of Nakia Wallace, and I believe that the allegations are accurate.
No, I think Ms. Schneider's question earlier pointed out, we knew that we could regroup and reassess. And so it wasn't necessary to make it a do or die decision. That if we dismiss the case against, for example, Nakia Wallace and a lot of other people, that would bar us from recharging a case against Nakia Wallace and other people. So I don't recall looking at it the way you described, because that kind of pressure was not on. It was more of a, how do we handle this load of work? How do we handle this docket? Are we going to get mired down fighting in this forum where we're losing momentum and a lot of people are unhappy in 36 to 14 as well as elsewhere? Or are we going to let that go and see if we can make better cases? And we opted for the second.
And Mr. Garcia, in reissuing a charge against my client, is there a reason why you didn't reissue the disorderly conduct offense that was initially?
I don't know, and again, I'm not trying to shirk responsibility, but I probably defer to Doug Baker on that. And I would ask you to see if he has a good answer, because it's going to be better than that.
One brief follow-up from your Honor's question. You spoke about the temporary restraining order, the TRO.
Yes.
Do you agree with the characterization that, as you mentioned in ex parte, that it's generally hard, difficult to obtain a TRO ex parte?
Your Honor, I object. I don't see how this is relevant.
Yes, I agree. I'm gonna overrule her. I mean, I'm gonna sustain what she said. Why is the TRO?
Okay, Your Honor, you open up the door, so I thought.
I asked them what a TRO was because y'all kept saying TRO and it wasn't defined on the record. I just wanted it to be defined on the record. That was my purpose of saying that.
Understood.
So, and I think he did go on, as an attorney does sometimes, and start explaining other things, but, yes.
Just briefly, Your Honor, we're almost done, Mr. Garcia, I promise. I'm gonna read the caption of the federal case to see if that will jog your memory about the plaintiff. Is that all right?
Please.
It was Detroit Will Breathe.
The organization.
Tristan Taylor.
I believe I remember him.
My client, Nakia Wallace.
Yep.
Are you familiar with Justin J. Bass?
Yes, yes. a shorter man, is that cool? Maybe not.
I'm short myself, so I don't
Okay.
have a good gauge, so we'll just leave that there. Lauren Rosen. Lauren Brennan. Does it ring a bell? Does Amy Lou Nahavivian?
Yes, I think that was the lady with the hip. Broken hip.
Zachary Colleget.
Yes, I think, he was a white young man. He hit the throat. Yeah, hit the throat.
He was hit somewhere. I think you may be referring to someone with a lung issue. Is that what you're?
No. I think he had a physical altercation with Mr. Colatier, and the officer touched his neck, in front of his neck.
All right. Lauren Brandt.
Well, I know there was somebody named Lauren, nickname or other name was Pete Moss.
That's Pete Moss Ellis.
Yes. Okay.
Olivia Puente.
I don't know.
Iman Sala. If I said that was the lady with the hip, does that ring a bell?
Yes. Yeah, that's right.
Margaret Hennedy.
Yeah.
Kaylee Arnold.
I don't know.
Alexander Annette. Does that ring a bell?
Yes. The last name of Nest was kind of sticks out as an unusual name. Can't picture that person or the events that were involved in the arrests, but the name does not.
Right, and Mr. Garcia, my math was off, and just reciting those names to you there, it looks like I said. Double check on that, okay. 14 names.
Okay.
All right, I think previously on the record, I said 9 or 10. So it's 14 individual plaintiffs, one organization?
Okay, that sounds right.
Okay, of those names, if I were to tell you that the folks who had an existing charge were Tristan Taylor, Nakia Wallace, Jackson Bass, Zachary Colleget, full stop. Does that ring a bell?
That does sound right. I think Mr. Bass, I'm not sure, but the other three names, I believe being originally charged, I would guess they were recharged. I think the videotape was pretty good for those.
Right, so they were recharging. So you're getting to my question about, so you said the videotape on those folks were good. And so you got that information from that preliminary review?
Asked and answered.
Okay.
We've gone over this. He already said his answer that. We have established that he has watched the videos and that he watched them for the first hearings and that we've established that.
Thank you, Your Honor. I'll move on. Did you review? I'm going to use your count. You said over 100. I can't remember your exact number. Your recollection. How many videos, body cam footage, do you recall reviewing in order to determine of that over 100 protesters, how many cases you were going to reissue?
I didn't. When we got to the point of reissue, maybe 10. But when those folks were charged and the tickets were stacked up in the water park, I didn't go looking at body cam video. After they were dismissed, and the task force screened out what they could find, they brought back a lot. And I think Doug and Shannon looked at a lot more tapes than I did, but I would say I looked at 10 or 12 examples that went with 10 or 12 people who were among those recharged. And I don't recall the exact number of who were recharged. I think earlier I said 12, 18. But that's just my foggy recollection from years later.
Last question. If I were to tell you that number was considerably lower, that it was more of 4 recharged, does that sound correct?
I thought it was high.
Thank you, Mr. Garcia.
Thank you so much. Thank you, Attorney Garcia, for your time today. You're all set. Hope your feet get better.
Thank you.
I have street outreach court this afternoon at 1:30. So I have to wrap this up so that I can go to the soup kitchen to do that this afternoon. Here's that you're gonna need a whole entire day. Is that what it sounds like to you all?
I think so. One of the two of them will take a long time, probably whatever one we do first. But then the second will be shorter, but
My next available day on Thursday is April 27th. Yeah, I'm trying to keep it on Thursday. Typically, my Thursdays are very light. I don't have a lot going on. I'm willing also, I don't have court in the afternoon. I can go in the afternoon as long as my staff is willing to come in that day, go the entire day. I will go the whole day so that we can try and get this hearing.
Your Honor, unfortunately, I have a oral argument in a different date, and circuit court that day.
The next day I have available is May 4th.
I am in a wedding that weekend.
May 11th.
May 11th is clear for me, Your Honor.
I'm here, Your Honor.
Can I quickly?
Absolutely. I was about to check with her.
It's clear for me.
The other people who are being called, they all work for the city of Detroit, so is that my understanding?
Yes, sir.
Okay, all right, so,
I don't foresee any issue. If for some reason there's like a medical equipment, I'll like.
all right, so we'll come back on May 11th, schedule it for all day long. So I will give you a break for lunch, obviously, so that we can go to lunch at that time. But we'll come back on May 11th. I know that's quite a bit of ways away, so if you do need to order the transcript, I will find out how to go about ordering that transcript, just so we can stay fresh. I think the court is able to order it somehow. I'll talk to my supervisor.
I can let you know.
Okay, let me know how to do it, and I'll sign the appropriate paperwork, so, just because I know it's a little length of time in between there, and sometimes we cannot remember all things. Also remember that it is live on YouTube, so if you need to go back and watch, but I don't know how clear the communication was online, so I don't want to be that only as our referral for this particular hearing. Anything further from you, counsel, at this point in time? Okay. Anything at this time?
Your Honor, just one point of clarification. When we came back on record, we jumped straight in. And so I just wanted to clarify, you made the finding that there was vindictive prosecution prior to the break?
For the sole purpose of the presumption. Just at that point in time. I haven't made a full finding.
Understood.
Of it.
Yes.
I'm just making presumption so that we can be able to hold the hearing, so I can hear the testimony of what exactly took place and what happened.
Thank you for
The
that.
sole purpose. I haven't found that they were vindictive yet.
I understand. Thank you, Your Honor.
At this point in time, so that's all it was, okay? All right, if there's nothing further, everyone's all set, bonds continue, Ms. Wallace, okay? All right,
Thank you.
You're welcome, thank you. You're on this, okay to release that. It is okay to release
Judge,
that.
before they go, as far as the transcript is concerned, can I get a date as to when you want it completed?
May.
It was May 11th.
May 5th, the hard ass?
No.
Okay. May 5th, that gives y'all about a week to be able to review this case and be ready for this next hearing?
Yes.
Fantastic. All right, take care.
Yes.
Thank you all so much.
Thank you, Your Honor. And then court report.
Sure, right here. May I have a list of the names that you were reading off?
Yes. Like I can just give you a copy. I'll give you a copy of it.
Oh, yeah.
It has the.
Just thank you.